Perfect. All right. So thanks everyone for joining us virtually for I guess it's been sort of a weekly September webinar on relevant issues pertaining largely to the pandemic. Um, Today's session is about the return to work. And so that's what I'm going to speak about. I'll just begin by acknowledging, even though we're sort of operating virtually, that many of us, including me and our offices, are on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people. And this area is now home to many diverse First Nations, Inuit, and Métis. Toronto is also covered by Treaty 13, which is signed with the Mississaugas of the Credit, and the Williams Treaty signed with multiple Mississaugas and Chippewa bands, and we're grateful to be on this land. And so I guess just by way of an overview, as you can imagine, a great deal has changed in the past month when we first started planning our speaking topics. Between June and August, we heard a lot about things opening up in the daily provincial updates and in municipal updates. More recently, and I think largely with the reopening of schools, those words are still kicking around, but there's a lot more, I think, at stake, and a number of other considerations as a result of the recent spike in rates of COVID-19. So this presentation is really intended to outline some of the risks and obligations that apply to workplaces that are either open or which may be considering reopening at this time. So just to give you a bit of a roadmap into what I'm going to be talking about, I'm going to discuss first the health and safety obligations that apply to the majority of employers in Ontario. I'm also going to discuss human rights considerations, focusing largely on the duty to accommodate that applies to employers. Third, I'm going to discuss the applicable leaves, including some of the new leaves of absence that have been introduced to the Employment Standards Act by the province of Ontario and which relate largely to COVID-19. And then I'm going to speak quite briefly, because I know we've covered this in the past, about layoffs of staff and terminations, and that kind of minefield, if I can refer to it that way. And hopefully we'll have a little bit of time at the end for questions. If folks are going to ask questions, I would ask that you post them in the Q&A box that should be located on your Zoom kind of app. All right, so as everyone knows, the province designated, actually, I'll take a step back here. So I'll say at the outset that what I'm sharing with you today is legal information. It's not legal advice, and that's in part because every situation, of course, has multiple factors, and it's not possible for me to understand sort of the specific situation you're dealing with, which makes it very hard for me to give legal advice. And so this is really this is information that that's being provided. All right. So getting into to the discussion, as everyone knows, the province designated certain businesses and jobs as essential services, and those entities have continued operating over the course of the pandemic. So we have frontline workers, of course, folks in the healthcare profession. We have administrators and maintenance staff at residential buildings, and a range of other professions that have not really had to consider the possibility of remote work, and perhaps haven't had the luxury of considering the possibility of remote work. That said, there are certain jobs that can be performed remotely, and so that's what this portion of the presentation is intended to address. If you are working in a field as an employer or a manager or supervisor in which the work can be performed remotely, it's critical, in my view, to assess whether it is in fact necessary or advisable to require in-person attendance at this time. So, part of the reason for that, and I'm going to get into the health and safety concerns and considerations for employers, is of course that there is risk involved in a number of activities where previously we wouldn't really think twice about them. But something like going into the workplace, whether it's in an office building or elsewhere, requires the employer to have a very stringent plan to ensure that you're mitigating the risks of transmitting COVID-19 in the workplace. And to that end, this first portion of the presentation is really to highlight the questions that you should be considering right now. Is on-site presence critical? The second consideration here really relates to concerns that I've heard from some of our clients who feel that it is preferable to have individuals in the workplace, even though the job can be done remotely. And a lot of what I've heard in that regard relates to team morale. It relates to questions and concerns around performance management, where supervisors feel that staff are not performing in the way that they would in the workplace. Um, and so in those situations, I would urge, again, folks in a supervisory role or in the role of hiring to think about alternate methods of performance management that you can use in order to ensure that staff who are working remotely continue to meet their responsibilities. Just because somebody is working outside of the workplace does not mean that they are not expected to meet the specific obligations and performance objectives of their role. And so if there are concerns, for example, about time management, about the quality of product, I would encourage employers to address those as they might for somebody who was going into the office, perhaps by having regular meetings to check in. If the performance is really a concern, by issuing a written warning, and then having, again, follow-up meetings to ask if there are things that can be done to assist performance. And I will also say, and I'm sure everyone is aware and perhaps has experienced this on some level, that morale may be low by virtue of the current sort of climate that we're operating in. And so that's something to be mindful of when you're considering the possibility of permitting remote work. All right. Okay, so moving on to the second sort of set of considerations that relate to workplace safety. So employers and workplaces in Ontario are governed by the Occupational Health and Safety Act, which is provincial legislation that establishes the need for employers to ensure that workers are operating in a safe and hazard-free workplace. And so it is, again, this is part of the source of the obligation to ensure a safe workplace. And specifically, the legislation requires employers to, quote, take every precaution reasonable in the circumstances for the protection of a worker. And of course, there isn't a definition in the legislation about what constitutes reasonable precaution. But we can get a lot of guidance from public health authorities, both provincially and municipally. So the city has a number of guides, including ones like the one on this slide, that highlight the specific precautions that need to be taken. So on a very high level, physical distancing, workplace modifications to limit spread through having hand hygiene stations and, if necessary, plexiglass barriers, developing policies and procedures to stagger start times and perhaps to screen staff. And finally, requiring staff to wear masks and possibly personal protective equipment. Some other kind of recommendations and precautions that you'll see in terms of public health guidance include managing entrance flow. So you might designate a certain area as the entrance, another as the exit. Ensuring adequate ventilation. This becomes an issue when you have individuals operating in a single environment with a shared vent system. Screening workers and supporting people with symptoms to self-isolate. Now, in this regard, you'll want to ensure that you are balancing the privacy of your staff with any kind of screening measure or any news that an individual does in fact have the symptoms of COVID. So you want to be very careful in managing that information, but having something like a self-screening questionnaire that individuals are required to complete or to respond to is advisable. Um, and then finally, working with local public health units if you are dealing with any workers who have COVID-19. Now, another area that is helpful, and I will also just say that this is obviously a very serious obligation, maintaining a safe workplace, and that's why the penalty for a finding that an employer has violated that is quite high. So in the case of an individual, it's a fine that could be as high as $100,000, as well as imprisonment for up to 12 months. For a corporation, and that would include, a nonprofit entity, a cooperative, a charity, you could be looking at as much as $1.5 million per charge based on an inspection by the Ministry of Labor. And I'll get into that process in a bit, but this is really just to highlight the importance and the severity and seriousness of these guidelines. Now, there is, of course, the case law that deals with reasonable precautions in this climate of COVID-19 is quite limited because as I'm sure many of you have sort of perhaps experienced yourselves, there is a real backlog at the tribunals, and cases are being heard, decisions aren't being sort of always released immediately, and so it's quite limited. But from what we have seen in the case law, there's a real emphasis on, first of all, the uncertainty of transmission, the fact that we know a bit and we can certainly rely on the advice that we get from scientists, which in turn are being relied on to develop public policy and public health guidance. But there's a lot of unknowns still about how this disease and virus are transmitted. And because of that, there's a need to constantly reevaluate the situation in light of changing information. Finally, one point that's very clear in the case law that we've seen is that regardless of the uncertainty, regardless of whether we can definitively say that masks prevent transmission 90% of the time or 50% of the time, it's very important to take the precautions that are being recommended on the provincial and municipal level. And so one case that really speaks to this is a decision that was made with respect to I believe it was a food processing plant that had around 80 workers. And in that case, the employer took the position that it wasn't reasonable for employees to have to physically distance because they were working in a line. And a worker complained about that, and eventually the matter was heard by the Ontario Labour Relations Board. And in that case, what's interesting is that the adjudicator relied on decisions that had been made during the SARS outbreak. And what they said there is that the precautionary principle is to be put into action in order to prevent unnecessary illness and death. As explained by Justice Campbell, this principle applies where health and safety are threatened, even if it cannot be established with scientific certainty that there is a cause and effect relationship between the activity and the harm. The entire point is to take precautions precautions against the as yet unknown. And so again, this is really to underscore how important it is to take really all of the recommended precautions in the workplace for the safety of workers, and also to avoid being fined, which is really the outcome where an employer is not heeding public health guidance. Now, in that case, and what you'll hear about sort of when we speak about the right of employees or workers to refuse work is really, again, provided for in the Occupational Health and Safety Act. So in that legislation, the employer is required to provide a workplace that is safe and free from hazards. And an employee can refuse the work where the physical condition of the workplace or the part thereof in which he or she works or is to work is likely to endanger himself or herself. Now, again, we come to that question. We're operating in a climate where people don't really know a lot. I mean, we know some, but there are still a number of unknowns with respect to COVID-19. That said, I think it would be reasonable for a worker to refuse to work in cases where an employer is not abiding by the public health guidelines, whether they relate to social distancing, wearing a mask, ensuring that individuals that have positive symptoms are not coming into the workplace. So, in cases where a worker feels unsafe in the workplace, they're entitled to refuse to work. And the process for refusal is that the worker reports the refusal to the supervisor or the employer. Um, and the employer and supervisor then investigate in the presence of the worker. Now, they might investigate and conclude that everything's fine. They might investigate and conclude that, something needs to be done, whether it's, encouraging people to wear PPE or taking steps to ensure adequate ventilation, et cetera. So at that stage, the matter is either resolved in that the worker agrees that they no longer feel endangered in the workplace, or if they still feel endangered and unsafe, um, they can continue to refuse to work, and they would then contact the Ministry of Labor. The ministry then sends an inspector to the workplace to conduct an investigation, and they issue a decision in writing to the worker and management about what they feel needs to happen, if anything, or if they feel that the workplace is safe, that it's safe for the worker to return to work. Um, so finally, if you've got a decision from the Ministry of Labor that settles, the worker can go back to work. If they still feel unsafe in the workplace, despite the order from the Ministry of Labor, their recourse is to go to the Ontario Labor Relations Board. So you'll recall the case that I just spoke about involving the factory kind of processing plant. That involved a workplace refusal that was escalated all the way up to the Ontario Labor Relations Board. And at that stage, you're basically you're before an administrative tribunal. You likely need to retain a lawyer and go from there. So that's kind of an overview of the landscape of workplace refusals. Um, I'll just address this now because I've gotten questions on this before. Folks who have asked whether somebody having a general fear or anxiety about COVID, whether that would be adequate grounds to argue that they're endangered in the workplace. And from what I can see, unless of course the anxiety is related to a mental health disability and would qualify for protection under the Human Rights Code, and I'll speak about that in a moment, a general fear of contracting COVID is not going to be sufficient grounds on which to refuse to do work, unless, again, you can point to a specific precaution that's not being taken or something in the workplace that you believe to be endangering you. Another question that I've gotten before, and which I'll just kind of address now, is whether taking public transit forms part of the workplace. And again, I believe that the answer is no. So, a complaint about, being endangered on transit would not necessarily translate to a right to refuse work. That said, again, I want to really encourage employers to think about the need for flexibility and to be sort of as understanding as possible with staff, given, again, the really unprecedented situation we're all in, and the very understandable fear about the risks involved in, particularly where it requires taking multiple types of transit to the workplace. There might not be grounds to refuse to work, but perhaps there are other options that can be considered with the employee, again, coming back to the possibility of remote work, perhaps a staggered schedule where they're, coming in at hours that doesn't require them to take transit at peak times. just really trying to be as flexible as possible so that everyone sort of feels safe and healthy in their work. All right. So the next kind of big area that I think is important to understand and um, to sort of know about is the Human Rights Code and how this relates to the workplace in a sort of COVID. I can't say a post-COVID environment, but in the environment that we're now in. And I'm sure there's familiarity with the Human Rights Code. Um, the Human Rights Code applies to employment relationships in Ontario, and it ensures that every person has a right to equal treatment with respect to employment without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. Now, those are a lot of grounds. And I think the two sort of grounds that are the most relevant to discussions about the return to work in this environment relate to family status and disability. And I'll get into why that is in just a moment. So, disability in the Human Rights Code is broadly defined. It is, and excuse me, even though it's not defined in the code itself, the Ontario Human Rights Commission has published quite extensive literature on the scope of this ground. So disability includes mental and physical disabilities. It includes, excuse me, conditions that are both visible and invisible. And so it's quite a broad category. Family status, as it's described in the Human Rights Code, is defined as the status of being in a parent-child relationship. So it speaks to the caregiving obligations that can arise in those relationships, and it protects from discrimination on the basis of being in a parent-child relationship. Now, the Human Rights Code, one of the ways that it protects against discrimination is that it imposes on employers and certain others, but we won't get into that. It imposes on employers what's known as a duty to accommodate to the point of undue hardship. Now, the duty to accommodate is really a legal obligation to explore alternate arrangements um, in order to allow somebody to be able to do their job. And when they say it's to the point of um, undue hardship is measured only by cost and health and safety. And I will say, and for any of you who've attended any of our sessions before on the Human Rights Code and the duty to accommodate, it's an extremely high threshold. So saying, it'll be more expensive if we let this person work different hours so that they can meet their childcare obligations. Saying that something is expensive is not going to allow you to meet the cost requirement unless you can show, with reference to financial records, that it would actually sort of impose such a significant burden on your organization that you may not be able to operate, just by way of an example. So these measures and these terms are not sort of just kind of fluffy. We think it would be nicer to have everyone present at this time, or we want X or Y. It really has to be supported by qualitative, and in the case of cost, quantitative evidence, or else a failure to accommodate would be a breach of the Human Rights Code. Now, getting back into what the meaning of the term is, again, accommodation really is a process. It's been described as a two-way street between the requester and the grantor. So in the workplace, the requester would be the employee, the grantor would be the employer. And if an individual requires an accommodation on the basis of, for example, a disability, which is something that I mentioned earlier, that's one of the grounds that's particularly relevant. they have a duty to comply with the employer in terms of providing relevant information. And the employer, in turn, has a duty to accept that information in good faith and to work with the employee to try to devise a solution. Now, one thing that's important to note is that it really is intended to be a collaborative process. So, an employee cannot demand a particular outcome to the accommodation request. It really has to be a back and forth with both parties participating meaningfully and in good faith and supplying whatever information may be required. Now, in the case of disability, so let's just speak sort of more directly about that. If an individual has, for example, a condition that renders them perhaps more susceptible or vulnerable to COVID-19 and to an infection, the process would be that they would notify the employer that that is the condition, and because of that, they require some form of accommodation. The employer may be entitled to ask for medical documentation regarding that particular request for accommodation in order to determine whether there are specific restrictions and limitations that a medical practitioner could advise of. So, for example, if they say they should not be in spaces with more than X number of people, or these are the specific restrictions and limitations, that information could be helpful for the employer. The employer then goes back to the employee, and if they have any follow-up questions, they can certainly ask them. But really, the outcome should be that the employer is able to propose a reasonable accommodation. So if we're thinking through it in terms of the workplace, that might be allowing the individual to work from home, as I mentioned previously. It might be considering whether they might take a leave of absence briefly, whether they qualify for any leaves, and I'll get into the statutory leaves, but whether there are any workplace kind of benefit plans that they could qualify under, whether they could come into, work at different hours from everybody else. Those are ways that the parties could hopefully negotiate some way that would ensure that the staff member is able to continue working despite having the disability that I described. When we talk about family status, and we're speaking about the reopening of workplaces, really employers may have to make adjustments to allow parents or caregivers to keep working while balancing their childcare responsibilities, unless it would be unduly costly or unsafe to do so. So, for example, if the person has a role where they're responsible for managing safety at a particular site, or their presence is critical to ensuring safety, can you get somebody else in on a temporary basis to cover certain shifts? Can you allow them to shift their hours so that they can meet their childcare obligations? Now, I think family status is particularly important in the current sort of childcare situation, where schools and daycares are opening, but are also sort of closing on short-term notice, where there are situations of potentially positive tests of COVID. And so you might have employees who are parents who are temporarily unable to come in, who are impacted by having childcare obligations, and who require an accommodation. And so the process in that case is the same as what I described in the context of a disability. Other than that, you likely wouldn't require a medical note. You would just ask the employee to supply information. That might include, what time is the daycare open? What time does it close? What do you anticipate, hours going forward will be? And then trying to devise a situation that, permits that individual, again, to be an employee and continue meeting their obligations while not having to sacrifice their childcare duties. Now, one case that is interesting here is a divisional court decision that looked at a claim of discrimination on the basis of family status. So in that case, the plaintiff had worked for a custom granite and marble company for 3 years, and then she took maternity leave for the birth of her third child. She ultimately didn't return to work because she disagreed with her employer about start times, and in particular wanted to start later in the day. She argued because of her childcare responsibilities. In that case, um, the divisional court rejected the claim of discrimination because they said the plaintiff failed to show how her right to care for her child or children was adversely impacted by her employer's requirement that she start at 8:30 every day. And they say specifically, there was no indication of how an 8:30 start time interfered with the plaintiff's ability to provide care both pre and post school for her children. There was a good deal of evidence about how the parties considered alternative start times, for example, 10 a.m., but overall, the plaintiff could not point to evidence that showed how she suffered adverse treatment and that her family status was a factor in that adverse treatment. And in that case, the court also said the employer had been lenient previously when the plaintiff was pregnant, and I believe she also suffered miscarriages. And so the employer was flexible with the later start time to accommodate those circumstances. But what the court said there is that lenience is not going to transform into a watertight obligation that the employer is going to be assessed according to. And so, in a situation like this, it may be worth considering from the worker perspective, what other alternative arrangements can I make to meet the start time each day? You know, what else can I do in terms of childcare? And on the employer side, you are entitled to propose an accommodation that makes sense based on the circumstances. So if in this case, and I'm not sure if this is the case, if in this case the employer got information that said, this person, can drop their children off to childcare prior to coming in and still be there by 8:30, they are entitled to say, unless there's something else that we're unaware of, we want you to start at this time because that's the time you start your work. So again, it's very helpful to remember that the duty to accommodate does not mean the duty to accommodate whatever somebody is requesting. It means based on the evidence and the information you have to propose a reasonable accommodation that will allow somebody to, in this case, meet their childcare obligations and caregiving obligations and also be present in the workplace. So that's helpful because I think the accommodation process sometimes is um, is misunderstood on both sides as to first of all what the employer is entitled to know. The employer is entitled to get enough information to ensure that they can devise some way that allows you to continue, operating in the workplace as an employee. Um, and at the same time, on the employee side, there's a real need for understanding by the employer, particularly in these circumstances, about what an individual may be facing. But again, it really is a two-way street. And part of the reason that you're not going to see sort of, here are 5 accommodations, because it depends so much on the specific facts that the individual is dealing with and the circumstances at play, because all of those things ultimately will alter what you're going to suggest when you're working to accommodate the needs of an individual staff member. So gathering that information is really important. And I'll also say that the courts have found in cases where an employee is not cooperating with requests for information, they found against them when there's a subsequent claim for discrimination. So that's a bit of a warning where if you are seeking an accommodation or if you receive a request for accommodation, there's a duty on both sides to engage in good faith in a meaningful process to try to arrive at a solution rather than, withholding information or refusing to participate, because that has adverse sort of consequences on sort of both ends. All right. And so the last area that I wanted to talk about was the applicable leaves that are available under the Employment Standards Act. Now, some of you may have employment contracts that set out, a certain number of sick days. You might have something for bereavement leave. Other types of leave may be mentioned in your employment agreements. So uh, those have to be at least what's in the Employment Standards Act, and possibly, and they could be more as well. They can't be less than what's in the Employment Standards Act. Now, there are a number of different types of leaves that are in the Employment Standards Act that permit leaves of absence for staff. And so, for example, you have sick leave, family caregiver leave, family medical leave, family responsibility leave, critical illness leave, bereavement leave. These are all statutory leaves of absence, which basically means it doesn't need to be in your employment agreement. It exists by virtue of the fact that you're an employee in Ontario. And these are basically leaves of absence that you're entitled to so long as you meet the specific criteria. And the length of each leave and the criteria for each leave is different. So, for example, you have sick leave as 3 unpaid days. Family medical leave allows employees with the right to take up to 28 weeks of unpaid leave from work to care or support certain family members who have a serious medical condition and are at significant risk of dying within a period of 26 weeks. Family responsibility leave is 3 unpaid days. So, this is just kind of to map out some of the different leaves that are available under the Employment Standards Act. Now, the leave that's probably of the most interest right now, and which was introduced by the government during COVID-19, is the infectious disease emergency leave. And this provides that employees who meet the eligibility criteria, which I'll get into in a moment, are entitled to take this leave until January 2nd, 2021, without penalty or any reprisal with respect to their jobs. Now, what are the eligibility criteria for infectious disease emergency leave? Employees are eligible where they are first under medical investigation, supervision, or treatment for COVID-19, or where they're acting in accordance with an order under the Health Protection and Promotion Act. And that includes, let me just find that here. Right, so acting in accordance with an order under the Health Protection and Promotion Act. Third, if they're in isolation or quarantine or acting in accordance with public health information or direction. Now, there's a long discussion about who is, what is public health information or direction. That can include a medical officer of health, an employee of the Board of Health, someone who's qualified to practice as a physician or a nurse in Ontario, the government of Ontario or Canada. So anyone who's in isolation or quarantine as a result of any of those directives, including a directive from their own physician, they would qualify for infectious disease emergency leave. If they've been directed by the employer not to work due to a concern that the employee could spread COVID-19 in the workplace, that person is entitled to take this leave. If they are providing care or support to a specified individual for a reason related to COVID-19, such as a school or childcare closure, or where an employee does not send their child to school or to childcare because of a concern that the child will come into contact with COVID-19. So that is very interesting because it, once again, it goes back to some of the caregiving obligations that I spoke about earlier that come up under the Human Rights Code. And so that really suggests that there may be multiple avenues to explore when you're working with employees who may have childcare obligations and who need to take time away. Now, infectious disease emergency leave, when it talks about providing care or support to a specific individual, it goes on to have a list of the specific individuals that would qualify as individuals who are receiving care from you. So you have the spouse, a parent or step parent, child, stepchild, or foster child, a brother, stepbrother, sister, or stepsister, grandparent, step grandparent, grandchild, or step grandchild, brothers-in-law, sisters-in-law, sons, daughters-in-law, uncles or aunts, nephews or niece, a person who considers the employee to be like a family member, um, and the spouse of an employee's grandchild, aunt, uncle, aunt, nephew, or niece. So it is a broad list of individuals, but ultimately, if an employee is providing care or support to that specified individual for a reason related to COVID-19, they would qualify for this leave. And finally, someone who's prevented from returning to Ontario because of travel restrictions. Um, and so you have here a leave that really is unlimited in length, except with the end date of January 2nd, 2021, where an individual who meets these criteria could take a leave of absence until January 2021, and where there is a duty not to penalize them or to terminate them during that time. So this is, again, another avenue to explore if you have, for example, a staff person who either qualifies for an accommodation under the Human Rights Code, or who, for any of these reasons, is not in a position to come into the workplace. So, these are the criteria that would enable somebody to qualify for this type of leave. Now, typically, an employee must generally advise the employer that he or she is going to be taking this leave. If that's not possible, they are required to notify the employer as soon as possible after starting the leave. Obviously, an employee is not going to lose their right to the leave if they don't notify the employer in advance. So again, I mean, I think this particular addition to the Employment Standards Act, again, shows the need to be sort of flexible and to provide leeway in this quite difficult climate that we're operating in to ensure really the health and safety of everyone. Excuse me. Now, I will say that, I've said that an employer, right? So I mentioned employers cannot threaten, fire, or penalize any employees who take or plan on taking infectious disease emergency leave, but this does not apply if the employment of the employee is ended solely for reasons unrelated to the leave. Now, this becomes a bit tricky because unless you've really documented a set of reasons that you are terminating somebody before they take leave, I think it would be quite, with the exception of specific well-documented circumstances, quite risky to proceed with a termination or penalty while somebody is away on this leave. But for example, if the employer's winding up, if the organization is closing down and people happen to be away on leave, then that would not be a breach of the Employment Standards Act, assuming you met all of your other obligations under the Act if that person were terminated. And finally, as a note, all of the leaves I mentioned, and there are many, operate independent from one another. And there are other leaves, of course. I haven't, there's pregnancy leave. I haven't listed all of the leaves here, but just to bear in mind that these may be other avenues to explore when you're working with staff. Okay, so I've got about 15 minutes, so I'm going to cover this off quite quickly and then hopefully leave about 5 or so minutes to answer questions. And I see that I have 2 questions in the Q&A. Now, this was perhaps more common at the start of the pandemic back in March, but there were a number of organizations and employers talking about laying staff off because of a reduction in services, because of a reduction in funding, For service industries, it was, just a bit inconceivable how, operations would continue. And so the question of continuing to employ staff becomes difficult. I know there's been a lot of information that I've sort of shared, but if there's one thing I can sort of say on this note, it's that unless the right to pursue a temporary layoff is specifically stated in the employment agreement for the staff person you're dealing with, it is extremely risky to unilaterally either reduce their hours or tell them that you're going ahead with a temporary layoff. And that's because the employment agreement is a contract between two parties who agree to specific terms. If the layoff is not contemplated there, it's a one-sided change to the contract, and it could put the employer at risk of constructive dismissal. And so it's important to be very cautious when you are considering a layoff or even a reduction in hours. One, alternative that I frequently have suggested is getting the consent or agreement of the employee to change the terms of the contract to say, you will not work on these, specific days, or your hours are going to be changing as follows, and get them to sign off on it. Because without that, it appears to be a one-way change to an agreement and could put you on the hook for the same amount of notice pay or notice that you would owe if you terminated somebody. Now, again, if there's no consent, it's a termination and the staff member is entitled to reasonable notice. If the contract does allow you to proceed with a layoff, the Employment Standards Act maximum layoff period is 13 weeks. So that's something to bear in mind. After that, if the idea is to continue with the layoff, the employer is required to make certain additional sort of concessions. So contributing to a benefits plan for the staff person, making some payments to them, and meeting certain other criteria. If you are dealing with a difficult decision to proceed with a termination, you need to ensure that you're giving reasonable notice to your staff. And the amount of notice, as I said, is going to depend on the language in the employment agreement, and more importantly, whether that language is enforceable. So some employment agreements will specify that the notice due on termination is the minimum under the Employment Standards Act, which is 1 week of notice per year worked to a maximum of 8 weeks. But there is more and more case law coming out which suggests that often the language in the employment agreement will not be enforceable. And if that's the case, you would owe much more than the minimum notice. You would owe common law notice. And that's a much higher, a higher threshold. So if you are considering terminations, for the longer term, I would really recommend speaking with a lawyer to properly understand your obligations and to avoid, a claim of wrongful dismissal from a staff person at this time. This is sort of common for our profession, I guess, but I always like to be asked a question before, I'm being asked to respond to a piece of litigation. So our preference is spend a little bit, of time and money getting the advice up front and treat it sort of like insurance against being sued down the road and having to spend much more. So that's the section on layoffs. As I said, I think we've got about 10 minutes for questions. And so I'll respond to the questions that are in the Q&A box. And I'm actually going to stop sharing my screen now. One thing that I will do though is, that was an error. Let me, I wanted to just put up while I'm responding to these questions. Yeah, I'll just leave this so that people can, these are resources that I've found to be quite helpful. The Ministry of Labor has a lot of really helpful guidance around reopening, same with the Occupational Health and Safety Act. And then the Human Rights Commission has really, again, really helpful guidance on how to deal with some of the human rights issues that arise as we, contemplate a return to work. So with that, I'm going to Okay, great. So the first question is, does the parent-child relationship also apply to a child taking care of a parent? The answer is yes, it does. It is viewed as a sort of it can be a two-way obligation. So if somebody has a parent and you're caring for the parent, you would likely be entitled to an accommodation under the Human Rights Code. And as you've heard, possibly also qualify for leave if you are assisting a parent who's dealing with some form of illness that's related to COVID-19. For example, if they are vulnerable to contracting the virus and if they have other medical conditions, that would be something to consider. The other question I've gotten is related to workplace refusals. At what point must the employee return to work? Well, so if, and maybe I'll just go back to, let me just go back to that slide because it's a multi-part process. So if the worker is, doesn't feel that the sort of the first stage was satisfactory, they can refuse to work with reasonable grounds to believe work is unsafe. Now, pending the Ministry of Labor investigation, which is the second stage, the refusing worker may be offered other work, as long as that doesn't conflict with a collective agreement. So if you have somebody who's refusing to do specific types of work because of danger they've identified, you can ask them to do something else. You can also offer the refused work to another worker. But there are certain requirements about who has to be present when that's done. And I believe that it's at the stage of after the Ministry of Labor investigation, if the ministry orders a return to work and there's a refusal by the staff person, I believe that there's the duty to pay that individual for their work stops at that time. But as I said, if the matter is still unresolved, the next stage is to bring an appeal to the Ontario Labour Relations Board. And so that's kind of that's sort of the landscape of workplace refusals. So hopefully that addresses those questions. I see that there's something else here. Oh, okay. That was just Fraser testing out the speaker function, I think. So that's all from my end. Hopefully this has been helpful for people, and I believe that the presentation is going to be available on our website, Fraser, if I'm not mistaken.
Yep, it'll be posted on our website, eilercampbell.com/education.
Excellent. All right. So again, if people have sort of questions afterwards, you can sort of consult with any of the resources I mentioned, or also visit our blog and get in touch with us. But hopefully we can all sort of work together in navigating this quite challenging time, which I think we all sort of saw things moving in one direction, and there continue to be unexpected things sort of arising despite that. But in any event, I hope this has been helpful for people, and I'm going to wrap up there. So thank you.